I am still a sitting judge, although on senior status in the federal court. It's been many, many years since I practiced law, actually 21 years ago. To answer your question, first of all, I think that my experience has always been the same. Judges try to get it right. I have sat on my circuit for now 18 years as a circuit judge. I sat as a district judge for a couple of years, and I've sat on 2 other circuits as a visiting judge, where I did not know who appointed the particular judges I was sitting with, nor did I know what their political affiliations had been. And to a panel that I have sat on, I have not seen political considerations make up part of the decision-making process. We do try to get it right, and there is a misapprehension out there that somehow it's all result-driven. Certainly in the courts of appeals, where we are constrained by what the Supreme Court has said, and we try to interpret the law with an understanding of what the Supreme Court has said the law is. Now, sometimes that's hard to do. If you have a 5-4 opinion and the 5 judges have written separately, and one of them says, I join the result, but not the reasoning, it's pretty hard to know exactly what they're telling you. And so...
Excuse me, could you just talk a little bit about the difference between an appeals court judge's role and a trial court judge's role?
Totally different. A trial judge is trying the case. He has the lawyers before him, he has the litigants before him, evidence is put before, if it's a judge trial, before the judge, if he's both trier of fact and the decider, or if it's the jury ultimately takes their instructions from the trial judge in deliberations on deciding how the case should come out. That's a totally different experience than being an appellate judge. An appellate judge hears cases on the record. The case has been decided, and usually the losing side wants to get it right, they think, and they appeal. And there are certain issues which they have preserved for appeal, and those are the issues which we decide. And we decide that on the record that's before us and on the law as we understand the law to be. Most cases are not hot-button cases. I think in the 18 years that I've been on the Court of Appeals, I might have seen 1 abortion case, maybe. There's a great...
People often picket outside your courtroom, or did they when you were...
There have been, there's some days when I come to work and there are pickets. I usually don't pay much attention. They may be, we had a death penalty case a couple of years ago. There were pro-death people and anti-death people out on the street. We do get that sort of thing. Occasionally with some of the terrorist cases, we've had people picketing. But I frankly ignore it when I come to work. I drive in, park my car, and go to work, and I don't think very much about it one way or the other. It does create security problems, but it doesn't create problems in our decision making. But the short answer in the federal system, and I'm sure in most state Supreme Courts, is we do try to get it right.
Judge Gamage.
I think every judge tries to get it right according to his or her lights. Judges are human beings. There are...
What does that mean, his lights? Does that mean
Pardon?
His background? Does it mean his...
It means we all bring our baggage with us. We do come out of different cultures. We do come out of different neighborhoods, different religious backgrounds, different ethnic backgrounds, different genders, sometimes different gender preferences. We all bring our baggage, our cultural baggage with us. A judge's duty, and I think this is what Judge Stahl was addressing when he says we try to get it right. A judge's duty is the fair and impartial administration of justice. In making those decisions, in determining what is the fair and impartial administration of justice, our unique individual thought processes are at work. On appellate benches, we sit there, we have a debating society. We argue. There are majority opinions, there are dissenting opinions, sometimes there are concurring opinions that go off in other directions. My favorite case when I was on the court was 4-4, four for the judgment of the trial court, four against the judgment of the trial court. No, 5 for the judgment of the trial court, 4 against the judgment of the trial court, 9-judge court. But only 4 for the prevailing opinion and 4 for the dissenting opinion. And that was done very calculatedly to avoid setting a precedent.
So it's perfectly understandable that Justice Roberts would think this way and Justice Souter would think that way, and they've both come to this question that they decided and acted impartially and did their duty.
According to their lights.
Right, according to their lights.
That's what the judge's duty is. We don't have 9 people on the United States Supreme Court, and in my case 9 on our state Supreme Court, because they're all going to think alike and vote alike. That's why there is a plural court. It has 9 voices on it, and you're expected to exercise your judgment independently and, where possible, to gain consensus. More often than not, it's unanimous on most appellate courts.
Is that right?
I can give you, for instance, just before I came here today, I got a 55-page fax of an opinion, which is the 3rd time I've seen it, and we are trying to reach consensus. There is a difference within our 3-judge panel about a couple of constitutional issues, and we've been arguing them back and forth for at least 6 weeks since the original first draft of the opinion was circulated.
Are you arguing back and forth over language or over principles?
In this case, it's constitutional principle. And so we will try to reach an accommodation among us where everyone is satisfied that we can have a unanimous opinion. Now, we may not reach that, and tomorrow morning, that's my job, is to decide whether I can accept this current draft in the form that it has been redrafted to meet objections of 2 of us to certain parts of what was hoped by the writing judge to be a majority opinion. You don't know whether that's going to happen yet, but that's the process. It's a give and take process. And those cases where there are contested issues of how you interpret the law, whether a right actually exists, and Judge is correct. We do all bring ourselves to the table. We are the sum of our experience. I was a practicing lawyer for many, many years. That brings a certain approach because I had clients. I handled some small criminal cases. My practice was largely in the commercial and government area, but I bring that knowledge with me. One of my colleagues on the Court of Appeals was a noted lawyer in Washington, D.C. on antitrust matters and spent time in the Justice Department in the Antitrust Division. He's an expert. He teaches at Harvard currently on the side antitrust to students. Obviously, he brings that vast knowledge of antitrust to the court when we are sitting on an antitrust case if he happens to be on the panel. By the way, in the federal system, all cases are assigned randomly so that it's on a wheel, and 30 days before the hearing date, I get the briefs. I understand what cases I'm going to hear that month. It's a random selection.
Let me ask Joe, because Joe's been doing this for what, nearly 30 years? Yeah. So you've watched a lot of judges come and go.
I have.
Is this true?